Civil litigation, this is your final podcast for this term. As you know, because I am certain that you've read the things I've asked you to read regarding trial preparation and appeals, this is essentially the end of the civil litigation case. And there's several considerations and expectations relevant to these final stages of trial preparation. Now, in continuing with comments I had made along the way, in particular, comments related to the expectation that we would be having, if you were my legal assistant or paralegal and I was the trial lawyer, or vice versa, if you were the trial lawyer, we would have had multiple regular reviews of the file or the case that is now ready to go to trial. And if we think about that for a minute, in my practice, towards the end, when I left the firm in the full-time practice of law, I may have alluded to the fact that I had somehow evolved into doing the majority of my work for two decent-sized clients, major clients, one health insurance company that you're probably familiar with, and I won't use the name, but and that company considered me their downstate lawyer. They considered downstate to be everything outside of Cook County. So that's Chicago, everything outside of the city of Chicago. So geographically, you can imagine that I was on the highway a lot for that client. And then, in an almost completely unrelated area of practice, I ended up somehow developing a relationship and had some success representing one of the largest insurers of truckers or trucking companies. Not exactly the drivers, but their employers in the large corporate trucking companies in major liability cases. So essentially cases where someone received a severe or fatal injury as a result of an alleged accident or allegations of negligence on behalf of someone driving a semi-tractor trailer on a highway in Illinois. That company had me trying cases throughout the state. So from every border, including Cook County. I had cases. I was in Chicago recently. I had cases on the Dan Ryan and the Eisenhower and within the city. So, again, I put a lot of miles on my car. Dean Weghorst and I communicated more by cell phone because if I was in town, I was on the road before she probably woke up to have her first cup of coffee and was headed to the office. And then I, a lot of times, didn't get back to town until after everybody had left the office. So it was a lot. And as we moved through those cases, it was imperative that we had regular reviews. We sat down and went through each file, and we would do that once a month. So she would block time in my calendar when I would be in the office where we would do what we called file reviews, and we would go through the file, each and every file at least once a month, to see where we were, where we needed to be, what we needed to have done. You may have gathered, am a little anal retentive or type A. whatever term you need to use. I like to have things done ahead of schedule. I don't like to go in and ask for extensions. I don't like to have things done at the deadline. I don't like to be rushed. And in the practice that I just described, you can imagine that there was no possible way that I could have done those things or operated in that way unless I wanted to be constantly on the cusp of malpractice or being in trouble with the court or having to apologize because I was in trouble with the court a lot. And that is not my style. So, we stayed on top of things. If I'm talking to young lawyers or new legal assistants or paralegals to litigation, would always advise you stay on top of the game, that you stay way ahead of schedule, that you plan things, that you just get things done, that you know if you have something due. For instance, we covered discovery. You know that discovery is typically due 28 days after it's served, so 4 weeks from the day that it's served. And so we would practice in a manner in which we did our absolute best and most of the time had those responses prepared and had those responses returned within that time period. It drove me nuts when I had to chase after somebody who was not of that mindset. And there are plenty of lawyers and plenty of legal assistants and paralegals who dilly-dally around or don't operate in that way. What I will suggest to you is that all this does is cause you stress. That's all it does. It doesn't make the work go away. It just causes you stress. And what happens is you have that 5-car pile up on the Murray Baker Bridge. It just ends up being one catastrophe after another eventually. So I would suggest you avoid it. And that's especially true when you get to trial. If you actually get to trial, remember, 9 out of 10 cases are likely to settle. So most cases will settle. Some cases don't settle until the eve of trial or the first day of trial. So you might have to do all of this preparation only to find out that you're not going to get to play the game. That also drove me nuts, by the way. I mean, I probably would say that in all my years of playing basketball or sports, I played basketball through college. I coached high school and college. Hands down, the most enjoyable part of any season was practice and building a team and being part of a team and working towards the common goal of being the best you could be at the end of the season. But I did enjoy the games. I mean, games were what you practiced for. And trial work is essentially like practicing all season and then having one game and then you don't get to play it because you settled the case. So as a trial lawyer, I enjoyed being on trial, being before the jury. But you didn't always get to do that, and it's not my role. If the case is going to settle and the case settled in a way that benefited my client, then the case should settle. But to be clear, we still go at it knowing that we may settle the case, but prepared to try the case to the best of our ability if we have to. So one of the first things you have to be able to do is understand your case. Now, if we've done the file reviews, if we've done that regularly, you understand the case. It's likely that the legal assistant and the lawyer know the facts at least an equal perspective, but I'll tell you that, Dean Whitehorse in a lot of instances probably knew the facts better than me. Her hands were in the file. She was actively working a lot of things in the file while I was driving around trying to get to the courthouse to the next deposition. But you need to understand the facts, and you have to review the case, and when it gets up to trial, you definitely want to review the case, understand the facts, the legal issues involved, and the arguments not just from your side, but from both sides. And for those of you who are new this semester or just halfway through or 12 weeks or so through legal research, you should understand that by now, and everybody else knows this. You're going to want to familiarize yourself with the case's procedural histories, all the key documents, all the pivotal moments, all the issues. You probably have a good understanding of the key players of the case, but you want to identify those key players, know the parties involved, the plaintiff, the defendant, the witnesses, any experts, and you want to understand their role and relevance to the case because it's essential for that effective preparation. The lawyer will have an idea of how they want to proceed, who they're going to put on first, what witnesses they will need in what order, etc. And that's going to be imperative at this point. You want to identify those key players. The next thing you're going to do is organize your case documents. You're going to want to create a document index, a comprehensive index of all the documents related to the case. Now, if you've kept your file in an organized manner, which surprisingly not everybody does, you probably already have a pretty good start on an index. So you have things divided up into pleadings, motions, discovery materials, witness statements, experts' reports, all the relevant documents. You have those separated out. You have an index that you can create easily. Your file is well organized. This is actually sometimes easier electronically, yet sometimes more difficult. And it's imperative that you stay on top of your file organization. When I say more difficult, electronically, it just can become haphazard if things are misplaced or put in the wrong place. Now, sure, you can do a search, which is much easier than back in the old days when somebody might have taken some part of a file that I was now looking for, and it was a paper folder. We had different colors for every different part of the particular litigation files. And if I was, say, looking for, I called them backers, the folder, the backer for research, and somebody had pulled that out of the file and not put it back, or it got put in the wrong file, that was not searchable. Not in the sense that you put in a little magnifying glass on your computer and it's maybe able to find out where this thing is. It was not searchable in that way. It was searchable in the way that you tear up the file room, going through every file to find what you're looking for. So more labor intensive. But if you keep your file organized, you can create this index, and that index is important. You're going to want that. One of the roles that legal assistants or paralegals are most involved in is helping with identifying and preparing witnesses, and especially witness coordination. So you'd work with the lawyer to identify potential witnesses, to schedule and conduct times to meet and prepare witnesses for what is to come at trial. Now remember, we can prepare our client. We don't always have the ability to prepare witnesses, and we don't prepare witnesses in the same way we prepare our clients. For witnesses, I probably would just make sure they had any documents that are relevant to their testimony, any past statements, anything like that, and give them that information as a courtesy. My client, I am going to take the opportunity to practice their testimony and give them an idea and practice what the cross-examination may be, how the other lawyer is likely to question them. So they have some idea, so it's not a surprise. Now, witness coordination, that's making sure that people are available and appear at trial. That's making sure subpoenas are issued. That's making sure that these people are informed of the trial dates, locations, and their roles, and that you're going to be communicating with them to make that experience as minimally disruptive as possible. In other words, if we're on trial for 4 days, typically we know if, the trial's expected to last 3, 4 days, 2 weeks, whatever. You also have a good idea as to when you're going to call that particular witness. So if it's a witness you don't plan to call until the 4th day, you're going to tell that witness that you'll be in contact with them along the way, and you will give them a heads up to the best of your ability, because we also don't have complete control over whether we'll actually get to them on the 4th day or whether or not we'll get to them by the 5th day. Likewise, we may get to them earlier. But we need to be prepared to coordinate with that person, let them know who's going to be in contact with them, and then do whatever we need to do to make that as minimally disruptive as possible. So help them with parking. Make sure that they have a comfortable place to be until they're actually called into the courtroom. Make sure that they know, okay, well, the judge has just told us that he's going to take an extended lunch, and so you aren't going to be called until 2 p.m. So if you want to go and do something else, but please be back here by 1:30. Okay, that sort of thing. Typically, that's going to fall on the legal assistant or the paralegal, if you're lucky enough to have somebody supporting you. And small firms, you may not have that ability. In fact, our firm was small, so if Dean Whitehorse worked primarily for 2 of us, and a lot of times that's the ratio, 2 lawyers to 1 legal assistant or paralegal. If we were both on trial, well, there were a lot of logistics that went into that. If my former partner was on trial down the street at the Peoria County Courthouse, and I was on trial, 3 or 4 hours away from the office, then I probably was solo on my own in Aquaka, Illinois or somewhere. The next major task is drafting and filing legal documents and preparing exhibits. We want to prepare trial documents, assist with trial briefs, motions, pretrial statements, as well as jury instructions. You remember when we talked about complaints, I said the first thing I typically would do anytime I was drafting a complaint in a given type of litigation was to go to the jury instructions, and then from the jury instructions, make sure that I had all of the elements of whatever the claim was that I was trying to draft a complaint for. We want to make sure that those documents are accurate, that they're formatted correctly, and they're filed within the court's deadlines and guidelines. And the court will tell us, for instance, on jury instructions, some judges may want, if the final pretrial, the trial's set to start on a Monday and the final pretrial's on a Friday, the judge may tell you ahead of time that the judge would like you to bring your proposed jury instructions to the final pretrial. And then one of the first things you'll do on that following Monday is the judge will raise any questions to try to get all that sorted out. And a lot of judges like to have the jury instructions ready to roll, so when the defense rests and we've moved on and we're ready for the jury, the judge can give a short break and go right into it. They don't like a lot of surprises, which none of us do, right? Exhibits and pretrial orders would be created at this time. And so you would prepare a list of exhibits and pretrial orders. You'd ensure that all the exhibits are marked or ready to be marked and organized for easy reference during the trial. We'd also want to make sure that we have all the equipment we need to present all of our exhibits. This is really a challenge depending on where your case may be tried. Now, some of the larger courthouses, or the larger counties, I should say, now have most of the courtrooms well equipped for the ability to display documents or videos or what have you. They have all the things. If you think about our smart classrooms, everything you'd have in a smart classroom. So technology ready. And a lot of the rural courtrooms or courthouses have at least a space and maybe more, but you might run into things like spotty internet. You might run into things that you can't anticipate. So one of the things that I always recommend is that the lawyer and whoever is going to be assisting the lawyer, legal assistant, paralegal, go to that courthouse and go to that courtroom and, figure it out. Know where you're going to sit. Know what you're going to need. Know if you're going to need an extension cord or your own display equipment for an expert's video or to show photographs or whatever, what have you. Know what you need. I'll give you a short story that I always like to share. We had a trial, and it was just down the street, the Peoria County Courthouse, and this was before the courtrooms were all equipped with all the smart technology, and we wanted to show a video. They had only one big screen that we could use, and it was being used, so we're told we had to arrange our own equipment, which meant we had to rent it and have it delivered. So the person who was organizing the rental was asked if they wanted a cart. There was a cart in the storage room. It happened to be an old computer cart that I had and in my office at one time, back when computer monitors weighed about 8,000 pounds. It was not my case. It was not my trial, so this is not my problem. It was decided to, rather than spend more money renting a cart for this big TV that would be used and rolled out at the appropriate time to show a video from an expert, that we would roll our own cart over there, the one that was discarded, into the old file room. The cart was rolled over to the courthouse. It was taken up to the courtroom. It was put in the courtroom. The TV was delivered. It was set on the cart. And at the time that the cart was to be rolled over so that the jury could watch the video, the lawyer started to roll the cart over to the area in front of the jury box when one of the wheels fell off the cart. That's why I discarded the cart. You would touch it the wrong way and it would seem the wheel would fall off. The cart started to tip. The TV started to fall. The lawyer strains his back, trying to hold both. The judge comes off the bench to help right the cart. The bailiff's running over there. The other lawyer, people from the jury starting to get up. They get the cart righted. They get the wheels set. They show the video. Could have been catastrophic. I don't know if it had an impact on the case, but it's a good lesson. Don't let the cart tip over, and know your courtroom. Know your courtroom. Had one other occasion where we were all set to go to trial. We had a computer, we had the projector, and we had all that, and we're in a rural county. No problem. Yes, problem. The only outlet remotely close to the area in which we were going to have the projector set up and needed to get the computer plugged in because computer batteries didn't used to be so great, was about 40 feet away. Had to take a recess, had to explain to the judge, had to find the local farm supply store and pay what seemed like an awful lot of money for an extension cord that was way too big for the job. Know your courtroom. Let's move on to creating trial binders. You're going to need either a digital trial notebook or a paper trial binder. And if you have your file organized, this won't be hard. If you have your index, it won't be hard. What these binders or notebooks include are key documents, evidence, depositions, deposition summaries. Remember, deposition summaries, that's what I use as I'm following the testimony of someone on the witness stand so I could cross-examine if I need to. And if you've done a good summary, you can go and look at that summary and you can follow along where their testimony is going. It also, I use the summaries more than the depositions prior to trial preparation to refresh my memory of what occurred at the deposition and highlight anything I needed to be focused about. So if they changed their testimony, were off in any way on their testimony, needed to have that testimony reviewed or cross-examined, I can do that. Okay, I can do that. That should be in this notebook or binder. Including also witness list, exhibit list, the list of exhibits we plan to introduce and with who. You know, I reference those witness lists and exhibit lists. I want to be able to know which witness is bringing in or I'm going to expect to introduce which exhibits. They need to be well organized, tabbed, and quick access. And if I have a legal assistant or paralegal in the courtroom, that individual is probably in charge of the digital trial notebook. They're maybe at the place where they can just go through and follow along and make sure we are doing what we said or wanted to do in that case. I talked a little bit about courtroom logistics, but again, making sure that the courtroom is set up with necessary equipment, projector screens, audio systems, check with the technology, make sure that you have everything you need for the technology, make sure it's functioning properly, make sure you have the things loaded on the computer that you wanted to have loaded or accessible regardless of internet access, as an example. And on the trial day, logistics for the trial include arranging for witness travel, coordinating with court staff, ensuring that all trial materials are transported to the courtroom and safe and secure during the trial. I was always a little wary about leaving my evidence in the courtroom, leaving my file in the courtroom. I'm just wary about that because I know that sometimes those things get moved. Sometimes those things go missing. Not necessarily for some nefarious, reason, just they do. So, if I was in a faraway land trying a case, then I would just badger the bailiff to maybe lock my stuff up somewhere or to make sure that the courtroom was locked. And sometimes I wasn't always, but sometimes I would just wait around to make sure the courtroom got locked. I'd just dilly-dally around until they kicked me out. Made sure the door got locked. As far as supporting the attorneys during the trial, there's real-time assistance and then just monitoring the proceedings. And real-time assistance includes that managing the documents, handling exhibits, taking notes, and addressing any immediate needs that might arise, like changes in the expectation for when a witness might be called because of the court announcing they have to go to the chiropodist or something. Monitoring the proceedings, you just want to pay close attention to the trial proceedings. Take detailed notes and track key points, objections, rulings, witness testimonies. Pay attention to potential jurors during voir dire. Share your observations. Share your concerns. I always wanted to know, do you see something that I didn't? Because there's a lot to see in a courtroom. I mean, in most cases, you have at least one other attorney sitting at the table across from you. You have 12 jurors. You have the court reporter. You have witnesses in and out of the jury box. You have the judge. You have the bailiff. You have people in and out. There's a lot of distractions, and you have a lot on your mind. So if you have somebody assisting you who can help monitor the proceedings, it's valuable to have their input. Now, I may just listen and nod, and I may say thanks, and I may say let's talk about that later. But be dialed in as much as the lawyer. So those are the needs up to the jury getting the case. So post-trial, what are the responsibilities? Well, after the trial, we organize and archive all the trial materials, make sure that everything's secure, all the documents, evidence, and notes. Make sure they're properly stored for future reference if there's, in fact, an appeal. If there is an appeal. If it proceeds to appeal, you assist in preparing the appellate record and drafting the necessary documents for the appeals process, and you have a better idea about what that appeals process is now. Now, it seems like there are a lot of appeals because the only cases that you can read about from Illinois are cases that went to one of the 5 districts of appellate court or the Supreme Court. But in the grand scheme, not many cases get appealed. So if it does, you know where to go back and look, and you know what to do. Final comments. Trial preparation is complex. It's demanding. Everything that we've talked about up until this final couple weeks of the class, it's complex, it's demanding, it's the paper chase. All so you can get to that race, to the start line, to the game, to be able to go to trial. But keep in mind that trial is also complex and demanding. In fact, it's the most complex and demanding of the whole litigation process. You finish the trial and you are worn out. It's a marathon. I used to be on trial. It was at a minimum a 16-hour day. I would usually be at the office or, if I was on the road, up and rolling way early. Whatever time I had to be at court, I had been up hours before that, preparing, thinking about, making sure I was ready to roll. You go through the day of the trial. You finish, and you go and prepare for the next day. If you're lucky, you're getting 6 or so hours sleep. And that's from the lawyer's perspective. Most of the time, my legal assistant or paralegal went home normal time. I did the prep. I stayed. The next morning, Dean Whitehorse might have came in to find a list of things that I needed or something I needed help with. But, she went home and got her sleep and had a meal and was with her family. Your organizational skills, your attention to detail, your proactive approach in this particular area of the law is valuable in anything you're going to do, right? But it's invaluable. And there's no amount of compensation, dollar amounts, no way to quantify it. It's invaluable. It's just, you won't regret being organized. You won't regret having attention to detail. You won't regret being proactive in your approach. And in my experience in litigation, it just leads to success. Do you always win? No. But do you win more than you lose? And do you settle in an acceptable area most of those 90% of the cases you're never going to go to trial, you do. I hope this was a good way to wrap up this course. It's the only way to wrap it up because that's where we end in civil litigation cases. I hope you enjoyed the course. It's likely that if you stay in the law, you're going to run into the things related to civil litigation. And in fact, if you haven't taken family law, that is a civil litigation area of the law. It is litigation, as many of you may know. I appreciate your efforts in this course. If you ever have any questions or concerns regarding anything litigation related and I'm around, you can contact me. If you need to talk to me about jobs, internships, the career, or schedules or anything else, reach out. And otherwise, if you need me, you know where to find me.